Good evening. My name is Kylie Mikel, and I'm a student at Jacksonville State University. I'm going to be presenting to you today a legal and ethical group project that was presented by me and two of my other classmates. This is for the EAD course, Law and Politics of Education, and I'm going to be discussing with you some of the legal and ethical things that have to do with education and how we are required as educators to follow these laws. The first topic I'm going to talk to you today about is religion in schools. Religion in schools has been a big debate throughout society. It used to, back in the day, schools would sponsor or even participate in school-sponsored prayer, but that is a no-no nowadays because of the First Amendment. So school-sponsored prayer is now banned. It is illegal based on the First Amendment rights of allowing people to decide and participate in their own religion. Um, Along with that, Bible reading is also illegal now because of that. However, it can be used as an instructional document, but it cannot be used for a religious purpose. It has to serve a completely secular purpose in order to be used in the schoolhouse. Silent meditation or any other type of devotional activities is not supported as well because of that First Amendment right. Also, on top of that, prayers at school sponsored athletic activities also violate the First Amendment clause, and so those are not allowed as well. And then there's also the question of student private voluntary prayer, which is permissible under the free exercise clause because it allows for students to exercise by choice their own personal religion, and it gives them the freedom to do so. It just cannot be sponsored by the school. It has to be their own free exercise of it and their own private choice to do so. Going hand in hand with the religion in schools topic, there's also the question of prayer at school events. Prayer at school events has been something that has been long done at things like graduation and games and school board meetings and that kind of thing. But administrators need to develop certain guidelines to make sure that they're protecting themselves from legal challenges that can arise from allowing these things to take place. The Supreme Court really supports that it needs to be student-led at all times so that the students can fall under the free exercise clause of the First Amendment. In order for it to be student initiated, they need to make sure that they're not relying on customs and community expectations because the community may have a certain idea of what should or shouldn't be done by administrators or educators or anybody that's employed by the school. But we have to make sure we're following the First Amendment regulations and ensuring that the students are the ones leading this, because it's permissible to have it at the event as long as it's not endorsed by the school official. So that means like the principal or the teacher, none of them are encouraging the students to do it. The students are doing it simply because they're allowing their free exercise clause to take place in this situation. This would also mean that it's not allowed at board meetings because this would be the administrators and the people who work for the school leading and supporting this. And the only way that it's allowed under the First Amendment is if the students are freely exercising it of their own volition and it's not technically supported by the actual school board instead of the students. The next thing I want to discuss in reference to religion in school is the equal access rule. And what this rule is talking about is that all religious or student clubs who are dealing with religion need to have the same rights and the same equal access that any other member does. This especially takes place when the administration does not have the same beliefs as that said club. So what this would mean is if you have a Christian club, and that is their religion, and you have a Buddhist club, or you have a Baptist, or you have a atheist, whatever kind of group you have in their school, you have to allow all of those groups the same rights in the school. That could mean having meetings on the school premises, having the clubs identified in a certain way, having them allowed to stay after school and access certain rooms. Whatever it is, any club that is in reference to religion has to have the same rights and be able to do the same things. And one club cannot be favored over another based on the administrator's own personal beliefs. You have to treat everybody the same in order to have any support of any religious activity within the school. This next discussion is going to be looking at the use of facilities by outside religious groups. This is going to be groups that are not necessarily attached to the school, so not really a student-based club, but basically a community-based group or event or something like that. Schools are usually like the center house of the town, and a lot of times they will use or allow the buildings to be used in order for certain gatherings, like maybe in the gym or some type of classroom or something like that when the school is not being used for instructional time. You just have to make sure that you're treating everybody the same to allow this to happen. So like non-religious and religious groups would be allowed the same access within the facilities, and that they don't have to accommodate religious groups under a closed forum policy. They also said that school officials should remain viewpoint neutral when allowing them or allowing an open forum because of this. Continuing to look at religion in school, it brings us to a good point, and that is Bible teaching. The laws about Bible teaching in a public school system say that it must be taught objectively and in a strictly knowledge-based manner, meaning it can't be taught from a religious standpoint. It has to be taught from a knowledge or a non-belief, almost non-belief way of thinking. It cannot be taught in a devotional type religious atmosphere, meaning you can't be trying to convert students one way or the other to believing a certain religion. There are instances where the Bible is a direct part of teaching in the classroom. Like maybe you have a Bible as literature class, and these classes are operating on a strict school secular program, meaning that they're teaching what the Bible is, what's in it, but they're not teaching it from a faith-based standpoint. They're teaching it strictly like here's what's in it, what was in it, and the knowledge component of it. And that in order to allow Bible teaching to remain in the schools, it has to stay from that same non-religious, knowledge-based way of teaching. Next up is the theory of evolution in reference to religion in schools. Used to be the teaching of evolution was banned because it directly went against the Bible teaching and what the Bible had to say about creation. But the U.S. Supreme Court actually ruled that you could not ban it because it's more of a science than a secular religion. So it's more about the scientific standpoint and the scientific side of evolution rather than focusing on the faith-based or the secular side of it. Um, this can cause a lot of problems between the scientific community and like religious groups. And so a lot of times what they're telling schools is to just go at it from a scientific standpoint, to teach about what evolution was scientifically, but not focus on whether it was true or not. And the ultimate decision about this, the evolution theory, is left up to the school board. So the school board gets to decide if they're going to teach about this or if they're not. And it's completely up to them, and whatever they decide is what their faculty has to support. The next section that's covered under religion in schools is the religious activities, and this is about anything that has to do with religion or anything like display-wise that has to do with religion. And the basis of this is that it cannot violate the Establishment Clause of the First Amendment. That means that the school is required to remain neutral in these situations. The school is not supposed to take a side one way or the other or choose one religion over another. They're supposed to remain completely neutral. And so this would mean that no religious displays or symbols or things like that inside the classroom or on bulletin boards, or some schools have even tried to post the Ten Commandments outside the front of their school. Like this would not be allowed because of that. Also, this would mean no distribution of religious pamphlets during school hours. And it would mean that students are not required to recite the Pledge of Allegiance based on their freedom of free expression, their right of free expression, because the Pledge of Allegiance does talk about one nation under God. And so students would not be required to say this, because then that would be requiring them to say something or declare a religion that may not be theirs, and that would not be accepted under the neutrality. Just like students have certain religious freedoms, educators and teachers do as well. For that reason, teachers are allowed to wear religious items if it doesn't create a uncomfortable or certain atmosphere that would make a student feel uncomfortable, because that would be their freedom of expression right in that instance. So they have to be respected too, as long as it's not violating the rights of another person. So school officials would be expected to make reasonable accommodations for a teacher's observance of special religious holidays. So whatever their religion may be, if they have certain things that they celebrate or certain things that fall under their religion, then school officials would be required to make accommodations, just like they would be required to make accommodations for the students. But in this case, they would have to have some type of documentable evidence to exempt from something or to have something that is against their religion. So, like, for example, if they were required to wear or dress a certain way, but their religion didn't allow them to do that, then they would have to have some type of document that said that their religion did not support that. Like, one thing I can think of in particular is some religions do not allow women to wear jeans or wear pants. They only have to wear dresses or skirts. So if their school was trying to require dresses or skirts of women, they would have to get something typed up that supported the fact that their religion does not allow this. And then they would be able to have that freedom because they have the same religious freedoms that any other person in society would. The next topic at hand here is the freedom of expression for students. It is defined by the First Amendment in the U.S. Constitution because it says that Congress shall make no law abridging the freedom of speech or oppress of the rights of the people. And this can be found in the Amendment 1 of the U.S. Constitution. This was also upheld in a famous case called the Tinker case. And basically what it said is that as long as whatever they're doing does not bring disruption into the school, then the students would have the right to have freedom of expression in that instance. In this Tinker case specifically, what happened was the students were wearing black wristbands because they were on strike against Vietnam government policy. And they got in trouble for doing that, and the school actually suspended them. And so they went to court, and the court ruled that it was actually unconstitutional to suspend them because the wearing of bracelets fell under their freedom of expression right because they were not disrupting school or causing any disruption to the educational process. There are specific instances in which a school may limit the freedom of expression for students, but it can only be in the following listed items. And number one, that would be is if the expression is a substantial disruption to the school, meaning it's interrupting the learning process or it's causing like a riot or it's causing things to be stirred up or issues to occur in the school, then the school would be allowed to step in and prohibit them from doing whatever they were trying to do in that instance because it's disrupting school. The second thing is if there's indecent or offensive speech, meaning if there's hate speech or just saying something ugly or offensive to another person based on their race or religion or something like that, then they would be able to stop that student from doing that, and that would not fall under the category of freedom of expression. The next thing is if they're breaking any school rules. So anything that's in the school handbook, students are required to follow. And if they're breaking those rules, then they don't have the freedom or right to just break those rules. There's also if there's destruction of property, meaning if the students are tearing something up or trying to break something or breaking in, then they would not be allowed to do that. That would not fall under freedom of expression. And no matter what it is, the students have to have due process of law before any action is taken. They have to have the opportunity to argue or go have their case defended before they are decided upon an action by the school. The next topic covered in the textbook is the search and seizure process. This is derived from the Fourth Amendment of the U.S. Constitution because it states that the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause. What this means is that people are not allowed to come in and search without probable cause or without a warrant. We are protected by that under the Fourth Amendment. So basically the simple definition of this is that we're protected under unreasonable search and seizure. However, this operates a little bit differently within the schoolhouse. Schoolhouse operates search and seizure under reasonable suspicion. So what this means is that if there is any type of reasonable suspicion, meaning from a reliable source, that there is something illegal or something that shouldn't be going on, the school has the right to search and seizure. And this was established in New Jersey versus TLO. And what they said that is warrants were not needed to conduct searches in schools because the school board has the right to maintain safety for all of their other students. So as long as the administrator is operating under individual reasonable suspicion, and that means for that specific student, this does not mean a general search, but a specific student, then they have the right to search and seizure that student based on that reasonable suspicion. In the search and seizure law, reasonable suspicion means that the search will provide evidence that the student broke the law or the school rules, okay? It means that the search has to be directly related to the incident and that they are looking for something specifically on that student that they broke or they did wrong. Students and parents and families should be given specific written policies that is given to them at the beginning of each school year so that they can understand that the following searches may take place. The first one is desk and locker search. Students may have their desk or locker searched at any time as long as there is reasonable suspicion that something is going on that shouldn't be. The student will have the right to be at the locker during this time if something is going on, but they do have the right to search it. The book bag search is a little bit more intrusive than the desk or locker because the desk or locker belongs to the school, but the book bag belongs to the student. So they have to have significant indication of reasonable suspicion, but they can still search it as long as they have that without a warrant. It just has to be individual reasonable suspicion that that student is breaking some rule or doing something that they shouldn't. The next one up is car search. So this would be like for student drivers. If the car is parked on school property, they are allowed to be searched. As long as there again is reasonable suspicion going on. The student and a school official can be present for the search. But a lot of times this kind of search happens when the authorities bring the drug dog around. And if the drug dog smells something, that creates the reasonable suspicion, and then the people are allowed to search the car because of this. And then the last one would be strip searches. These are a lot less unlikely to happen. They can occur, but only under extreme health and safety conditions, meaning that it's an absolute must to protect the rest of the student body. Like if you thought they had a gun or a knife or something like that, that was going to directly put other students in harm. Whenever a student is caught breaking the law or doing something that they're not supposed to in reference to the schoolhouse, they must be offered due process as in the Fifth Amendment of the U.S. Constitution. It states that it prohibits the government from depriving a person of life, liberty, and property without due process of law. What this would mean is that you have to do an investigation. You can't just automatically assume and accuse somebody of something unless you've done the full due process of law, meaning you get fair treatment from the government. There is 4 components to due process, and it's called procedural, substantive, vagueness test, and the presumption test, which is what we're going to talk about next. First up is procedural due process. This guarantees that certain steps are followed in order for the student to be making sure that their rights are followed. It allows the student who's being accused to address something before an action is taken, meaning the student would be allowed to address what is going on before they were suspended or expelled or anything like that. And it requires notification of the charges and proceedings, meaning that the school would have to notify the student and in most cases the parent as well before they go forth with whatever is going on. There's also the substantive due process, and this requires a valid reason that is reasonable. So basically what this is doing is protecting individuals' rights. It means that they are guaranteed freedom to not be taken without going through the proper procedures, meaning they can't just be expelled, or suspended or even arrested until they've gone through the proper procedures of charging that student and notifying them and notifying parents and that kind of stuff. Due process means it's also put through the vagueness test and the presumption test. The vagueness test means that if a rule or law is too vague, meaning it's too general, you can't really understand what it means because it's too widespread, then a person can't be held accountable for following the law. So this would be like if there's a general statement that says you can't do something, but it's not specifically stating, it's kind of hard to understand, you don't really know what it's saying, then when it went to court or when it went to due process, it would not be required for that person to have followed that law because they couldn't understand exactly what the law was talking about. There's also the presumption test, and what this does is it protects people from being accused of something that there is not facts or evidence on. So what this test says is that there must be factual evidence supporting the breaking of the law. This means that you can't operate on assumption. You can't just assume that something happened or something was done. You have to have factual evidence that it occurred. You have to have found something or have something that you can say, here's the proof of what happened, and this person should be charged because I have this proof. Under the FERPA law, students and their school records are required to be protected at all times. This means that the school district should be operating and following the policies and procedures of FERPA at all times. They're also responsible for notifying students and parents of their rights under FERPA so that they can know what is required of the schoolhouse. And that's what this means is that they should be maintained, they should be confidential, they should be locked up, and they should not have any corrections or adjustments made unless the proper means or measures have gone. Also, under liability in student records, school personnel should try really hard to avoid labeling children. That means that these records should contain strictly the facts. So, for example, in a disciplinary infraction, there should just be things about what happened, the time, the place, and the witnesses, and no assumptions or opinions or comments about the student or about what the educator thought or what the administrator thought. It's strictly about what happened, how did it happen, when did it happen, just straight facts. Students should be present when information is being recorded on a disciplinary infraction so they can know exactly what is going on in it because they have the right to know that about themselves. And after this is over, school personnel should not talk about these records at all to a third party because they are required under FERPA law to maintain that student's confidentiality. Also under liability in student records, according to FERPA, student records should never be removed from a secure location unless there is proper authorization. Usually these records are kept behind a locked door or a locked cabinet or even a locked computer screen that is password protected to make sure that the students' records cannot be accessed by just anybody. It has to be somebody that is allowed to. What this would mean is that you can't release information to anybody unless you have proper identification. Meaning if this person that is requesting the records has nothing to do with the student and nobody business having the records, then you would not be allowed to release the records in that instance. Next, under educational laws is the Individuals with Disabilities section, and this is talking about the Individuals with Disabilities Education Improvement Act, and this act specifically says that federal law ensures that eligible children with disabilities between the ages of 3 and 21 or until their graduation receive a free, appropriate education consistent with their educational needs. What this means is that the school is responsible for meeting the specific needs of that student, and it's their job to identify and try to do everything they can to make sure that student has what they need and they're supported at the local school. This normally has to do with the LRE, which is the least restrictive environment. And basically what this says is that students should be allowed to be in the least restrictive environment possible. Meaning if they can be and operate in a regular school setting, general ed classroom with supports and accommodations by the special education teacher, then they should be allowed to do that. They shouldn't be separated and thrown into a wing unless that is absolutely necessary. If there is a way to get them into the general ed class like every other student, then they have that right to be in that least restrictive environment as well. Because of this Individuals with Disabilities Act was developed, the IEP was also developed. An IEP is an individual's education plan, and this is just simply a document that is outlining the services and supports that a student with disabilities is going to receive. This is a legal binding document, okay? It does not matter if there's funding, it is required, and each student who qualifies for it must have one. It has to be analyzed and updated each year. This is normally done by the special education teacher who has their case, and they work with the student throughout the year to make sure that their goals are being met. The stakeholders within an IEP normally consist of like the special education teacher, the parent or guardian, the principal, an LEA administrator, and a teacher. And sometimes there can be disagreements between those parties, disagreements between the parents and the educator about what should be going on for their kid, what they think is best for the kid versus what the teacher thinks is best for the kid. In this case, when all parties don't agree, then the parents will have to appeal to the state if they cannot work out the issue within themselves. Individuals with disabilities are operating on a different way and set of beliefs than general ed students, and because of that, they're handled differently in reference to their disciplinary procedures. What this means is that students who are disabled do not receive discipline based off their behavior related to their disability. So if they have a disability that causes them to yell out or throw things, they would not be disciplined in the normal way that a general ed kid would because they would be allowed accommodations based on their disability. Lastly, I want to discuss with you the Alabama Code of Ethics. This is a set of rules or standards that teachers in Alabama are required to operate by, and it falls into the following 9 categories. There's professional conduct, trustworthiness, unlawful acts, teacher-student relationships, alcohol, drug, or tobacco use, public funds and property, remunerative conduct, and maintenance of confidentiality or abandonment of contract. I'm going to go through each of those and just give a short little summary of what each of those means so that if a teacher is trying to learn about the Alabama Code of Ethics, they would understand what is required of them. The first one is professional conduct. What this means is that educators are required at all times to conduct themselves in a professional manner, meaning that they should be operating a learning environment that is safe and productive for all of the students. The second one is trustworthiness, meaning that they can provide correct and transparent information in the work environment. They can be trusted to maintain things like confidentiality, or they can be trusted with students to do what's right and professional by the students. The next thing is unlawful acts. What this means is that teachers are required to follow all local, state, and federal laws at all times, meaning they're not arrested, they're not breaking rules, they're not breaking rules of the local school board. They're following the rules and doing everything that they should be at all times. The last one on this slide is in reference to teacher-student relationships, and this is a huge problem in our society today. We're seeing more and more on the news where teacher-student relationships are becoming highly inappropriate. The Alabama Code of Ethics specifically states that these relationships have to remain professional at all times, and that firm boundaries are set to ensure that a relationship never crosses the line from professional to unprofessional, and the educator is responsible for ensuring that this does not happen. Next up on this slide, we have the discussion of alcohol, drug, and tobacco use. And educators, obviously, because they're required to follow all state laws, should not be using illegal drugs at all times and should not be under the influence or possession of alcohol while on school grounds. Since alcohol is legal, they would be allowed to do what they want in their own personal home in reference to alcohol, but they cannot be under the influence or in possession of it when on school grounds or a school function or anything like that. The next thing is public funds and properties, and this would mean that educators ensure that they are using the funds and property ethically, meaning that they're not stealing money or not using the property for their own gain. They're specifically using it for the thing that it is required for. The next thing is ruminative conduct. This means that any gifts or compensations should be accepted with integrity and cannot be a conflict of interest. The next one is maintenance of confidentiality. So as we discussed earlier, educators are required under FERPA to maintain confidentiality of all students, meaning if they know something about a student or something happens with a student, they are not allowed to go and share that with someone else. And the last thing is abandonment of contract, meaning that educators are required to carry out all duties in their contract, and if they do not, then they are subject to dismissal. The basic gist of this presentation is to get you to understand that laws are in place to keep ethical boundaries for all people under U.S. Constitution. Everyone is required to follow a certain set of laws, and educators are even higher in this because they're responsible for teaching and training students. And so there's certain things that they have to do to ensure that they're remaining professional and following the law and raising up the next generation. Thank you for being with me today as I presented on the legal and ethical requirements of educators. All of this information came from the In-School Law in Public Schools, a practical guide from Educational Leaders textbook, and the Alabama Code of Ethics. All of these things can be found online if you want to learn more about how to be an ethical educator.